Morning, everybody. Welcome to the Inside Edge. It is Wednesday, November 19th, and Deputy Attorney General Levi Klinger Christensen found himself in a fairly tough spot yesterday. He represents the Atlantic County Board of Elections, and when a judge asked for guidance on disputed provisional ballots and VBMs, his hands were tied because his client, two Democrats and two Republicans, were deadlocked. And Klinger Christensen said that he was representing an entity that had competing concerns. And he's right, that's not his fault. And that's been a problem in recent years. The Globe has called out deputy attorneys general for telling judges that they represent the Board of Elections when the board never authorized them to take a position. In New Jersey, the Attorney General's office provides representation to all state agencies, including the Board of Elections, even though they're technically part of county government. And as a result, when a voter faces possible disenfranchisement, the Attorney General's office is in an adversarial position rather than advocating for the voter and for voter rights. And yesterday's hearing was, it was full of lawyers. Deputy Attorney General Klinger Christensen, the county counsel was there representing the county clerk. There were lawyers for the Democratic and Republican parties, but there was no one in the room advocating for the voters whose ballots might be rejected. It was a little bit different during early voting and on election day. Voters were offered some help from the ACLU, from the New Jersey Bar Association, Democracy Defenders, but only if they asked for assistance. And a voter who is turned away from the polls has the right to appear before a judge and defend the right to vote. But too often, the Deputy Attorney General, following the lead of Susan Scott, the Assistant Attorney General who runs the election division, they promote a form of disenfranchisement. They tell the judge why the voter shouldn't vote under the statute as they see it, and then say they take no position on the outcome. But the Deputy Attorney General meets with the voter in advance of the hearing, and they don't always disclose that they're on the other side. And instead, they conduct what is essentially an intake interview. And one voter told the judge that she didn't realize it was, in her words, an adversarial sort of meeting. We reported that the voter had emailed Deputy Attorney General Drew Hedden proof that she changed her address, but he never mentioned that to the judge. And fortunately, the judge allowed her to vote. But now get this: instead of advocating for the voter, Nicole Adams, the Assistant Election Section Chief, who works for Scott, ordered at taxpayer expense the court transcript, which is never done in a matter of one voter appearing before the judge. But she did it in order to do some reputation defending for Drew Hedden. And it was a feeble attempt at that. And all of a sudden, the Attorney General's office is in the reputation defender business when it involves one of their own, but not as much when it involves other people or voters. Anyway, that's all I have for today. Thanks for listening, and I'll be back tomorrow.